Welcome to the NCDWI Guide podcast, where defenders of the Constitution assemble to prepare for courtroom battle and firm owners gather to develop marketing strategies that will revolutionize the practice of criminal defense. Here's your host, the NCDWI guy, Jake Minnick.
Hello, fellow freedom fighters, and welcome to episode 240 of the NCDWI Guy podcast. On today's episode, we are talking about the fresh off the press, newly minted decision of State versus Clark. State versus Clark. This case is about substitute testimony of a state lab analyst who is utilizing a previous lab analyst's report in offering their own testimony without doing independent testing of the lab. So we're going to look at the decision, but also kind of look at ChatGPT in basically helping us to analyze this decision, what it can do in looking at a case. Just have been playing around with this a little bit today and wanted to share some of the findings from ChatGPT in addition to sharing some of the information about State versus Clark. So State versus Clark really relies in a large part on the recent United States Supreme Court decision of Smith versus Arizona. I covered that United States Supreme Court case back on episode 222. So if you're interested in really the law related to State versus Clark, you have a case coming up where this is an issue, make sure you go back and listen to the Smith versus Arizona episode 222, where we do a deep dive on that. But today we're going to be talking about State versus Clark. This was decided on December 3rd of 2024. The Court of Appeals number for that is COA 23-1133. COA 23-1133. And this involved a substitute analyst of a testing of drugs, methamphetamine, basically the testing of that substance. The original testing analyst was no longer available at the time of trial. And so the state sought to offer the testimony of another lab analyst who had not independently done any testing on methamphetamine, had read the previous lab analyst's report. The state did not try to admit the actual original lab analyst's report into evidence, but basically sought to get it in vicariously through the substitute analyst who had read it and was using it as the basis of their opinion. So I asked ChatGPT, I downloaded State versus Clark from the Court of Appeals website into a PDF. I put that into the $20 paid version of ChatGPT and basically asked this prompt: analyze State versus Clark attached. And so here is what ChatGPT walked through, and basically I'm just going to share this because it's also a good brief of the decision. So here's the case. It begins with case overview. North Carolina Court of Appeals, filed December 3rd, 2024. Defendant was Melvin Howard Clark. Charge was possession with intent to sell and deliver methamphetamine. Judgment vacated and remanded for a new trial. The key legal issue: whether the admission of expert testimony based on another lab analyst's lab report violated the defendant's Confrontation Clause rights. All of that on point in terms of the case overview. It then went on to ChatGPT then went on to address what it called key points of the decision. So, Confrontation Clause violation. The Confrontation Clause of the Sixth Amendment guarantees the right of an accused to confront witnesses against them. In this case, Mr. Cruz testified as an expert, basing his opinion on a lab report prepared by Ms. Fox, who was unavailable to testify. Mr. Cruz Quinones, I left that out on the first one, but it did have that. Mr. Cruz Quinones did not independently test the seized substance, relying entirely on the hearsay contained in Miss Fox's lab report. Again, all of that is correct. It then provided the legal precedent, Smith versus Arizona, 2024. It says the Supreme Court held that when an expert relies on testimonial hearsay statements, it implicates the Confrontation Clause. Testimony based on another analyst's report is inadmissible if the defendant cannot cross-examine the report's author. State versus Craven as well, 2013. Lab reports created solely for evidentiary purposes in criminal investigations are deemed testimonial and subject to Confrontation Clause requirements. That was both of those cases were correct, and the State versus Craven case, and that part of it specifically was extremely central to the court's ruling in Clark. So it's interesting that it pulled those two cases, which are the main two precedents for State versus Clark's decision, and specifically that one kind of point from Craven was really important because as the Clark court pointed out, in the recent U.S. Supreme Court cases analysis in Smith versus Arizona, the court in that case did not really decide whether or not the lab report from the Arizona crime lab, was testimonial or not. They had sent that back to the trial court to determine whether or not the statements contained in there in the lab report were testimonial. If not, then likely not subject to the Confrontation Clause. If they were, then they were subject to the Confrontation Clause requirements, and it would be problematic to have offered those without the original analyst being there to talk about the report itself. So, again, what the Clark court says is that, yes, that is what Smith versus Arizona says, but then also because of State versus Craven from 2013, lab reports created for evidentiary purposes in criminal investigations are deemed testimonial and subject to Confrontation Clause requirements. And I'm just going to pull a couple of things myself out from the Smith case to that point, or I'm sorry, from the Clark case to that point, and then we'll kind of go back to ChatGPT's follow-up and some of the additional prompts that I gave it in terms of helping me draft cross-examination questions and a motion to suppress based on the Clark ruling. So, here is kind of the relevant portion that we just got in terms of the summary from ChatGPT. This is from the actual opinion of State versus Clark. This is a direct quote. Based on our Supreme Court's holding in Craven, we must conclude Mrs. Fox's hearsay statements contained in her report and relied upon by Mr. Cruz Quinones without independent testing are testimonial as a matter of law. The record before us shows Mrs. Fox's report was created solely to aid in the police investigation of defendant as a matter of law. Nothing in the record indicates the report was created to aid in the provision of health care to the defendant or for any other reason, unlike perhaps a hospital's blood toxicology report prepared at least in part to aid in the provision of treatment to a defendant. Indeed, the lab report here shows on its face that Mrs. Fox conducted the testing for the quote Avery County Sheriff's Office, end quote, in connection with an investigation of the defendant. It states above Mrs. Fox's signature that, quote, this report is to be only in connection with an official criminal investigation, end quote, and that it, quote, contains the opinions / interpretations of Mrs. Fox, end quote. The report also identifies itself as, quote, an official file of the North Carolina State Crime Laboratory, end quote. I think that portion in particular is really helpful because, again, what it says that is, as a matter of law, these types of lab reports are testimonial in nature as a matter of law. And the kind of form or standardized language used within these reports is basically the same across the board. I think that even if that standardized language was removed from a report, it's hard to argue that these reports testing for the substance within a drug at the request of a DA's office or a police department, or the testing in a DWI case of a defendant's blood for the presence of impairing substances is not for testimonial purposes. The whole purpose of the report is to hold up in court to verify that the substance is what it says it is, or that the blood contains the substances that it says are present within the blood. So I think that is incredibly on point. So getting back into the ChatGPT analysis, after going through relevant case law, it says application of Rule 703. Rule 703 of the North Carolina Rules of Evidence allows experts to form opinions based on inadmissible data if such data is reasonably relied upon by experts. However, constitutional rights under the Confrontation Clause take precedence over evidentiary rules when testimonial statements are involved. Again, both of those are on point when it comes to State versus Clark. Then ChatGPT says the court's reasoning. The lab report created by Ms. Fox was considered testimonial because it was prepared solely to aid law enforcement in prosecuting the defendant. Mr. Cruz Quinones's reliance on the lab report made it essential for the defendant to cross-examine Ms. Fox to challenge its contents. The absence of Ms. Fox denied the defendant this opportunity, violating his Confrontation Clause rights. Outcome: the Court of Appeals vacated the judgment and remanded the case for a new trial. The state's inability to provide admissible evidence of this substance's identity, which in that case, in Clark, as ChatGPT notes, was methamphetamine, through independent testing or testimony from the original analyst, rendered the conviction invalid. It then goes on to talk about the implications of State versus Clark. So really thorough kind of case brief, if you will, on State versus Clark. Again, I have done some in the past when I was using the unpaid version of ChatGPT, and I just asked, hey, find and analyze State versus Clark with this specific case number, and ChatGPT is effectively pulling that from offline. I was getting some funky, inconsistent answers. Again, in this case, what I did was I downloaded a PDF version of State versus Clark into ChatGPT, asked ChatGPT to analyze State versus Clark, and it was an extremely detailed and on-point analysis of State versus Clark. Where else might this be helpful? I'm just in terms of other uses for ChatGPT, obviously with cases that you're quickly trying to diagnose. Let's say that you have the prosecution arguing a case to the judge, and you have no notice of that case. Is there a way that you could quickly download a PDF version of that on your laptop and ask ChatGPT to analyze that when you've just been handed a 40-page case from the state, and obviously don't have time to read that. I mean, you can ask the court to have time to analyze and respond. Maybe the judge is reading it while you're doing that analysis. But again, there is some, kind of other ways that you could use this analysis just beyond kind of briefing a case for yourself, real-time court interaction. I then asked ChatGPT after it did its case brief to do a legal memo. And so in legal memorandum format, ChatGPT basically did a summary of the Confrontation Clause, Rule 703 of the Rules of Evidence, Smith versus Arizona, Melendez-Diaz versus Massachusetts, State versus Craven. It then basically, because I had asked it to do it in a kind of like argument for exclusion, did a argument section of the legal memorandum as well as a conclusion. So, from law school, the issue, rule, analysis, conclusion, the IRAC or the crack, version of doing a legal memo, it immediately spat that out with all on point information. Nothing that I could find that was incorrect in terms of the legal analysis. May be a little bit shorter, but I could have probably asked it to expound upon certain issues that it was finding. If I had added in after this, said, prepare a legal analysis based on Smith versus Arizona, Melendez-Diaz versus Massachusetts, and State versus Craven and State versus Clark, if I put all of those into the kind of prompt, I expect it would have been able to do a more full analysis, because it's effectively, as far as I can read it, pulling information primarily out of the memo or out of the case that I fed it. So again, the more information that you're giving ChatGPT, more likely the better the output, so to speak. After the legal memo, I asked ChatGPT to create a motion to suppress the evidence of testimony of a substitute analyst where they did not do independent testing and the original analyst was unavailable. It immediately spat out a amazingly well formatted and legally on point memo. Here's the beginning of that. Comes now the defendant, and then in parentheses it has defendant's name, where you would put that. By and through undersigned counsel and respectfully moves this court for an order suppressing the testimony of blank substitute analyst's name, in parentheses, as inadmissible under the Sixth Amendment to the United States Constitution, applicable state constitutional provisions, and binding case law. In support of this motion, defendant states as follows. It has a factual background, and it's really helpful in terms of like what the factual background has. I'll just kind of briefly read this because it's pretty amazing, like how detailed the factual background is. It says, on blank date, law enforcement seized blank, which was basically the drug, powdery substance, whatever evidence there was from defendant. To the seized evidence was sent to blank laboratory name for forensic analysis, and blank original analyst name performed the analysis, performing a lab report identifying the substance as blank methamphetamine, example in this case. Number 3, original analyst's name blank is unavailable to testify at trial. The state now seeks to introduce testimony from blank substitute analyst's name, who did not conduct any independent testing on the evidence, but instead relies on blank original analyst's name, report, and conclusion. So again, just, really like well formatted and kind of like to the point reason for the factual basis of the motion to suppress. It has a very brief but squared away legal argument where it again points to Smith versus Arizona, Melendez-Diaz, and itself, State versus Clark, and then talks through lab reports being testimonial in nature. The substitute analyst testimony relies entirely on testimonial hearsay section. Defendant has had no opportunity to cross-examine section, and then basically a conclusion, which again is in kind of like the legalese formatted legal conclusion, and then has basically a signature section where you can insert your name, law firm address, city, state, zip, phone number, email address. So again, just on point in terms of the motion to suppress. I then asked it to draft that motion to suppress in a Word document. So it then basically generated a Word document with the same language that was contained in the ChatGPT prompt section. The formatting of that motion to suppress was not the greatest, and I tried to give it a template to generate a motion to suppress kind of based on how I format it. Didn't spend too much time on that, but it didn't have the greatest formatting. But in terms of the body of the motion, could easily have been cut and paste from the document that it generated into kind of my templated motion to suppress template. Then I asked it to prepare cross-examination questions by the defense, by a defense counsel of a lab analyst who has not independently tested the lab results on which he or she is basing his or her testimony. So here's the cross-examination questions generated by ChatGPT. So first section is called qualifications and role. And here's the questions under that section. Could you please state your full name and current position? What is your educational background and training in forensic analysis? Are you certified in any forensic disciplines? If so, please describe. How long have you been employed in your current role? What is your role in this case concerning the analysis of evidence? Section 2 is labeled by ChatGPT as independent testing. And here's the questions under that. Did you personally perform any testing or analysis on the evidence in this case? Were you ever in physical possession of the evidence during this case? Can you confirm whether the evidence was tampered with, contaminated, or otherwise mishandled at any point? Do you know the procedures? Do you know what procedures were used to ensure the integrity of the evidence during transport or storage? Section number 3 is labeled by ChatGPT as reliance on original analyst. And this is the questions in that section. You testified that you are relying on the lab report prepared by, in parentheses, original analyst name. Is that correct? Do you know, in parentheses, original analyst name? Have you worked directly with them before? Did you observe, again, in parentheses, original analyst name, performing the analysis of the evidence? Are you aware of any errors, omissions, or procedural deviations that may have occurred during original analyst's testing? Can you confirm whether original analyst followed all required laboratory protocols in their analysis? Section 4 is titled by ChatGPT specifics of lab report. Have you renewed all raw data generated by original analysts for this case? Are you able to verify that the instruments used in testing were properly calibrated at the time of analysis? Do you know whether any quality control measures were conducted during the testing process? The lab report you relied on indicates, in parentheses, specific findings. Can you personally attest to the accuracy of these findings? How do you know that the conclusions in original analyst's report are correct? Section number 5 is labeled by ChatGPT as confrontation and opinion testimony. Here's the questions under that. You've stated your opinion, and the substance is, in parentheses, substance identified. Is your opinion solely based on the conclusions reached by, in parentheses, original analyst's name? If that original analyst had made an error in their analysis, would you have any way of detecting that error? Without personally performing the testing, how can you ensure that the results presented in this case are reliable? Is it fair to say that your testimony here today is dependent on trusting the work and conclusions of, in parentheses, original analyst name? Section number 6 is labeled by ChatGPT legal and ethical standards. Here's the questions under that section. Are you aware of the legal requirement that a defendant has the right to confront the witnesses against them? Do you believe that your testimony, without independently verifying the evidence, satisfies the standards of scientific reliability and fairness required in criminal proceedings? And number 7 is titled by ChatGPT as conclusion. And here's the questions under that section. Would it be accurate to say that your testimony does not add any additional scientific validation beyond what is stated in parentheses, original analyst name report? In your professional opinion, would independent testing of the evidence by the testifying analyst provide greater confidence in the accuracy of the results? So again, great starting place for building a cross-examination of a lab analyst. Again, this could be done with all types of cases. It could be done, cross-examination of an officer when the circumstances allow for that. If you're trying to create a motion to suppress a legal memo for some other type of case, there's just a ton of value in ChatGPT. My law partner, Lance, shared with us a couple of weeks ago in one of our mock trial sessions some of his findings, kind of similar analysis of the North Carolina DWI seizure statute, and asked for an analysis of the statute, a legal memo, motion to suppress, a draft order, and really had, again, some similarly incredible results. As we all know, you don't just turn something in given by ChatGPT as, just gospel. You've got to independently verify anything that you're arguing, verify that, cases being cited are still good law, that they are, actually saying what they purport to say. And it's always, always, always a good idea to independently read the cases. You are going to get more from reading State versus Clark, in its full form than just by reading a summary. Just like in law school, if you just read the brief of any case, you get the gist of it, but it's sometimes hard to summarize a 50-page United States Supreme Court opinion in, a page, or 4 paragraphs. I mean, like there are with some of the case briefs. So similar issue, you're going to get more from a full reading of the case. And there can be some specific examples or language within the case that are incredibly helpful. I think some of that language in State versus Clark as to why SBI lab reports of substances or blood are testimonial in nature by law. I think there's some really good language from the Clark holding on that point. But again, ChatGPT can be a huge source of information and also a amazing resource in terms of helping to generate documents, in terms of helping to generate cross-examination questions, a opposing viewpoint, argue against this case, whatever the prompts are. There's some pretty incredible results available in the kind of latest version of ChatGPT, and particularly in the paid version. So anyways, just wanted to share some of those uh, kind of results, findings from an analysis by ChatGPT of State versus Clark. Again, I think that the holding in this case is relatively straightforward, but it is huge because we all know in blood DWI cases, a lot of times the original testing analyst is not there by the time the case rolls around in trial in district or superior court. And so this is a in some ways it's just a kind of reiteration of Smith versus Arizona, but I would say it also takes Smith versus Arizona one step further because in Smith versus Arizona, the question was somewhat left open as to whether a lab report would be considered testimonial, at least when it comes to SBI lab testing in North Carolina of either blood or drug substances. This seems to kind of say that by law, as a matter of law, these types of reports are testimonial in nature, and therefore the Confrontation Clause does come into play related to those lab reports. So just wanted to share that. Best thing to do when it comes to AI and the amazing ways that it can transform your law practice, help you to improve within your particular practice area, is to go and play around with it and test it out. So go play around with it. Share your findings. I would love to hear back from anybody that is, utilizing a ChatGPT in an interesting way. I'd love to share that with the audience, and also selfishly love to take advantage of that myself. So, I'm new in the game, just playing around with ChatGPT. There's a lot to learn. If there's anybody that can do it better than me, which is probably a lot of the listening audience, please share so that I can provide that value to everyone else, as well as take advantage of it myself. Hope you all enjoyed this episode, and I look forward to speaking with you again next time.